welcome to the Parleys Creek Subdivision, the General Adjudication Public Meeting. I am Blake Bingham. I'm the Assistant State Engineer responsible for the Water Rights Adjudication Program within the Division of Water Rights in the Department of Natural Resources. Before we get underway, I just point out a couple key individuals here that work within the Division of Water Rights. We have Kent Jones, who is the state engineer. He's the ultimate boss of the Division of Water Rights. He's the executive director of the Division of Water Rights. Historic title is state engineer. Next to him is Ben Jensen, who's from the Attorney General's office. And next to Ben is Gary Brimley, who's my assistant. And then we also have John Bream, Josh Zimmerman, and I saw Jeffrey around here somewhere, who are kind of my boots on the ground guys who will be out there taking claims, and you'll probably interact with them more than the rest of us. But just to kind of lay the groundwork and give you guys a heads up, I understand when you receive this notice and this summons, there may be some misunderstanding. This is you're required to be here, that you're obliged to be here. Any point in this presentation, if you feel like this is not pertain to you or you're done listening to me, feel free to stand up and walk out. It won't hurt my feelings, and we fully understand we are all very busy. Also know that this is being recorded and it will be available on our website. You're welcome to continue filming with your camera if you'd like, but it can save you some battery power. It will be on YouTube, as well as this presentation will be available for review as well on our website tomorrow. As I go throughout the presentation, if you feel like you have a question which may apply generally to the group, feel free to raise your hand and ask that question. I'm happy to answer those. If the questions become a little bit more specific, maybe and tailored to your own specific situation that don't have applicability to other members in the audience, maybe hold off on those, and I will stay here until the last question is answered. If I feel like we're kind of straying a little far afield, I might kind of bring it together and try to proceed, just so that not everyone's time is wasted and we can get through this presentation in a timely manner. Presentation takes about 45 minutes depending on the number of questions we receive. Usually what happens is everyone's scared to ask questions until someone asks one question, and then the floodgates open up and we start answering questions for about 15 minutes, then I have to drive on. But if you feel like you have a burning question, feel free to raise your hand and we'll try to get an answer as best I can. With that introduction, let's go ahead and kick this off. I apologize there's probably many of you, or maybe some of you in this audience, who have seen this presentation before. There's not a whole lot of new material. The jokes are still the same, so I apologize up front for that. This is the agenda. We're going to talk about the concept of an adjudication, give an overview, and then we'll talk about the proposed determination, some of the steps involved, specifically pertaining to those who receive the notice or the summons and what those next steps are. So we'll try to kind of spell out exactly what you're required to do going forward if you have a water right. And we'll even talk about what is a water right. And then we'll talk about some of the significant issues and the anticipated timeline for this process to take place. And we have questions at the end, but again, if you have questions throughout, please raise your hand and we'll answer those. All right, so first question off. The first thing we like to do is give a little bit of background as to what is a water right. There's probably a lot of diversity of understanding with respect to this process. So first of all, what is a water right? Well, a water right is a right to divert water from a natural source, such as a stream or an underground aquifer, and beneficially use that water. It has several different facets to it. Among those are the nature of the beneficial use, for instance, whether that use is for irrigation or for your house for domestic purposes or for stock watering. There are several different uses that could be it could be utilized for. A priority date, and a priority date is in essence when that water was first appropriated or put to use. And what that does is it holds its place. It's kind of like its figurative place in line compared to other rights. So if you have a more senior water right or an older water right, you get to take your water before junior people in that line. So that's the system of priority we have in the state of Utah. And we'll talk a little bit about how that has evolved and what that means. Has a defined quantity water allowed for diversion. That is typically represented by a flow rate in cubic feet per second, sometimes abbreviated as CFS, or by an annual volume measured in acre feet. If you can imagine a yard that's an acre in area and 1 foot deep, that's the volume of water delivered on an annual basis associated with an acre foot of water. It has a specified point of diversion. It's a technical term for where you take the water away from the natural source. So for the groundwater, the point of diversion would be the well. For a stream, the point of diversion would be a head gate or something off that stream that physically diverts it out of that stream bed. And then a specified place of beneficial use, it is what it sounds like. It's where it's being used, whether that's a house, whether that's a certain area of irrigation, a 40-acre tract. Those are the components generally associated with the concept of a water right. So we get a lot of questions when we send out these notices. And again, I think in this area we sent out like 11,000 notices. And there's a reason for that, and we'll get into that. But a lot of people have questions such as, do I have a water right? How do I know if I have a water right? And generally our answer is, well, you would probably know because you would probably be maintaining that wellhead, or you'd be maintaining that head gate off the stream. So you would probably know if there is a water right associated, or if you have enough reason to continue to participate in this process. Sometimes you might have ditches running through your yard, or a ditch off of a large stream. So those are the types of things that may evidence or suggest the existence of a water right. What a water right is not. It's not a share in an irrigation company, and that might be kind of a concept that's foreign to many people, but an irrigation company is like it sounds. It's a company that owns water rights, and then they sell shares of that water to their shareholders, okay? And so often people will own shares in an irrigation company, but they don't have a water right. So the irrigation company would be responsible for participating in this process, not necessarily the individual shareholder. It's not a connection to the public water supplier, such as Salt Lake City Public Utilities. Now, Salt Lake City owns water rights, and then they distribute that water to those who pay their bills, obviously, within their service area. And so Salt Lake City is very active in this process and is participating on behalf of their clients, right? The people who purchase water from them. So it's not the water that you get through your water meter, in essence, what that boils down to. Okay, so it's hard to fully appreciate why we do a general adjudication without giving a little bit of context to how this has evolved over time. The theory of water rights has evolved in Utah. And so many of you are probably familiar with the Mormon pioneer history about they actually entered the valley. The advanced party entered in July 22nd, and then July 23rd, they diverted the waters of City Creek to kind of soften the soil so they could get a late crop of potatoes planted. And so that was kind of the first, one of the first things they did when they arrived in this, what we now know as Utah, is divert water and start beneficially using it. And then they build their shopping mall on top of it. Later on, Brigham Young, understanding the vital resource that water was, made the declaration that there shall be no private ownership of the streams that come out of the canyons, that these belong to the people, all the people. And that's really formed the basis of how Utah water law has continued to evolve. In essence, the water is owned by the public. The state administers these water rights, but at the end of the day, the water is our resource as the public. And so this is really just an administration of a public resource, is what the Division of Water Rights does. Through 1847 on through 1850, what we now know is Utah kind of went through this transformation. It was first a part of a part of old Mexico, right? And then it became this quasi-ecclesiastical state of Deseret, and then finally became the territory of Utah. However, regardless of what shape or form or government system, really the government was church-centric, because that was the only thing that was here, that was an organizing body. As a result of that, the diversions of the streams were generally done on a communal basis for the immediate needs of the settlers. The system, or the doctrine of priority, remember I talked about a priority date, kind of evolved from that concept of the first settlers got there, started digging ditches and diverting water, and so they got the primary right, and then subsequent settlers who came got whatever water was left over. And so you had this concept of primary and secondary rights. Hey, we have some more seats up here. Feel free to come on in and just, you're not disturbing anyone. Just come in and find a seat. You're all right. So that concept of priority evolved through that fashion of settlers, and it was later mingled with kind of this concept of first in time, first in right. And so we kind of function under a hybrid system that way. Conflicts were settled through ecclesiastical channels. You had bishops' courts for kind of local issues, and if you didn't like what the bishop had to say, you'd go to the stake high council, and they would set it straight. And so the church kind of functioned as the ultimate authority in figuring out these water disputes. Well, as we enter the territorial era, the first territorial legislature made an attempt to kind of divest the church of that authority to administer water, and they gave it the authority to the county court for timber and other water rights related issues. However, Salt Lake County was really the only place where that kind of took hold. The remainder of the territory was, again, still pretty church-centric, and even those county courts, you know, the judges there were the bishops and the stake presidents anyway, so it was really kind of moot. And so at the end of the day, it didn't really change much, although it kind of was shown that there was this slow, gradual evolution from church leadership to maybe more of a government agency. In 1877, the Desert Land Act was passed, and really the primary significance of that is it delegated to the states or the territories the responsibility for administering and appropriating water. And we kind of look at that now as a foregone conclusion, but if you think of how the government operated, they were very much in the business of issuing land patents. You had to go get a land patent in order to be a homesteader, right? So you might think, well, the same applies to water. Well, this is a pretty significant act that made it so that the state or territory would be the governing body for administering and appropriating those water rights, and also kind of severed the ownership of the water from the source. So you could divert water here and use it on land way far away from where the source was, which is different from how the riparian water rights would work back east. Well, due to failure of that 1852 Act, the legislature tried to appoint these county selectmen who would kind of act as ex officio water masters. Again, it worked or they tried to implement in Salt Lake County, but very few counties grabbed hold on that. Again, the church was pretty much the main administrator, and people continued to divert water without regulation. As a result of that, confusion over existing rights continued in spite of the best efforts of the territorial legislature or the LDS church. And the church continued to administer those rights. A great example is the High Council decision of 1879 that split the waters of Spanish Fork Canyon. They continued to operate on it, and that decree or that decision, in essence, shaped how water is still diverted out of the Spanish Fork Canyon. Obviously, they have subsequent decrees over on top of that, but that formed the basis for those initial distributions. So now we go into the statehood. So in 1896, there was a huge debate over whether there should be a water law or not, because they were worried that the state would go ahead and take everyone's water rights away, in essence, void all the existing water rights. And so they're trying to figure out if they should come up with a comprehensive water law. It was too contentious, so they decided, all right, we're going to punt, but here's what we're going to do. We'll put it in the Utah Constitution that all existing rights to the use of any waters in the state for any useful or beneficial purpose are hereby recognized and confirmed. So in essence, if you had been diverting water and using water, you were good to go. You were still authorized to do so in the future. But they didn't come up with any type of comprehensive water law at that time, just because it was so contentious. They weren't sure which direction they needed to go. In 1897, however, the state created the Office of the State Engineer, but he was pretty much given the responsibility for mapping out where these stream sources were, taking measurements of flows, approving plans for dams and those types of things. But appropriating new water rights was still done in the old-fashioned way, where you'd go and you'd stake your claim, and then you'd go file it at the county courthouse and the county recorder, and that's how you would appropriate a water right. Again, largely ignored. In 1902, the United States Reclamation Service was created to reclaim the arid West, right? And they do this by building these huge projects, like big, giant reservoirs. And and then use those reservoirs to irrigate the arid West. Well, they were really reluctant to build any of these projects in any state or territory that hadn't adopted some type of comprehensive water law or a system for figuring out what rights were already on the books, or maybe not on the books, but being used. And so they said, hey, until you guys get your act together, until you guys have some type of water law, we're not going to build anything in your state. And so 1 year later, state of Utah decided to comply. They established a comprehensive water law that called for the recording of all existing water rights and the adjudicating of those rights, meaning looking to see what all these historic rights were being adjudicating, making sure they're still legitimate. However, they kind of just told the courts, all right, you now have this authority, figure it out, let us know if you have any problems. The biggest problem being that they didn't really provide any funding to the courts to do that. There was really no technical know-how from the courts. In essence, how does a court go out and actively adjudicate something? Usually what happens is people bring suits to them, and they weigh facts and law and that type of consideration rather than going out and actively adjudicating stuff. And so there was nothing that really took place at that time. Well, finally in 1919, the legislature came up with the idea, well, what we'll do is we'll have the state engineer. He'll go out and he'll initiate these adjudications. He'll have people file claims, and then he'll take those claims, he'll review them, analyze them, compile them into a proposed determination, and then file that with the court. And then the court can just use that as the basis of their decision. And that's largely the same format that we use today with some minor tweaks. In 1935, they finally realized that groundwater and surface water are interconnected. And so prior to 1935, you didn't need a water right to drill a well. However, after 1935, they said, hey, it's the same water, whether it's surface water or groundwater, it's all hydrologically connected. You do need a water right to do that. And so prior to 1903, you didn't need a water right to have any type of diversion, whether it's surface or underground. And then 1903 hits, you needed a water right to do surface diversions. And then 1935 hits, and you had to need a water right to do both surface diversion or an underground diversion. So that'll help give you some idea. So we have a lot of wells in the Salt Lake Valley that were drilled prior to 1935 because there was no need to have a water right. And part of the adjudication process is going and finding those wells and making sure people file claims on them so they can become of record. And we'll get a little bit into that here in just a bit. So prior to the enactment of the Comprehensive Utah Water Law in 1903, water rights kind of fell into 5 different categories. You had those that were declared by ecclesiastical fiat. You had those that were filed for record at the county. They were just kind of recorded somewhere and then stuck on a shelf and never found again. Those that were decreed by a court, those were typically involved just limited parties. One person would sue another person, and the court would decide to make the decision between those two parties rather than everyone on that same stream. You had contracts or agreements among limited parties. And then you had those claims that were never manifested on any record. These are the people that were diverting water, didn't really have any contention, didn't need to take it to court, so they never brought their claim forward. And so as a result of that, there's a number of issues. There was no public record. There was no consolidated public record where you could go and find these rights. Over-appropriation was rampant because there was no public record, and because they weren't defined, there was controversy with regard to who had water rights, and they were generally settled either by the court or ecclesiastical decree. In his 1902, so the state engineer is required every 2 years to file a report. And so in one of his first reports, he made this statement. He said, now keep in mind this is before the 1903 Water Law Act, so before the adjudication concept had even evolved or been statutorily defined. He said, the definition of existing rights appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made a public record. So the idea was we were going to adjudicate all of these old rights before we started appropriating new rights. Well, as you can probably have figured out, that never happened. They decided to go ahead and appropriate new rights and adjudicate as we go. And so here we are. And we'll talk a little bit about the Utah Lake Jordan River adjudication, of which this is a part of. Here we are these many years later, still adjudicating, trying to find out these existing rights and make a clear delineation of their facets and how they work. So what is a general stream adjudication, sometimes called a water rights adjudication? Well, it's an action, just like its name implies, it's an action in district court. It binds all water users, not just a limited number of parties, but all water users in the state, as well as the state engineer, or the otherwise known as the Division of Water Rights. That's the title of code it's governed by. And then the first general stream adjudications took place back in the 20s. So when I talk about the Utah Lake Jordan River General Adjudication, if you look at that purple blob, I'm going to point to it here with a laser pointer, right there, for you people right there as best I can. That's the Utah Lake Jordan River Adjudication. So it goes Salt Lake Valley, down through Utah Valley, up into the watershed of the Provo River, up into Heber. Okay, so that's why it's shaped like that. It follows the hydrologic boundary of the drainage to Utah Lake and the Jordan River and the Provo River and Spanish Fork. So all those river systems are part of this one big civil case. But obviously, and how it started actually kind of interesting is that during the 30s there was a huge drought. There were a lot of people who were diverting water out of the Jordan River. So Salt Lake City decided to sue like 2,000 people. Said, hey, you guys can't divert that water. That's our water. And it eventually got transferred into the general adjudication. So they filed suit, I think, in 1936. The court said, hey, this is too big of an issue to decide among limited parties. We're going to turn this over into a general adjudication and bind all parties. So that's why it's huge. But now, because it's so big, we just take it a bite at a time. So the bite we're at tonight is the Parleys Creek portion of this drainage. But it's still part of this overall Utah Lake Jordan River general adjudication. Okay, so why do we conduct general adjudications? Well, we want to bring all the claims onto the permanent record. Remember this guy diverting water without, reckless abandon up in the hills somewhere, never filing a claim? Well, we want to find him, and we want to find that person who has an old well in their yard they've been using, but didn't realize that they needed to have they should be on the record, and they have a water right to divert that well. So that's one of the things. We want to bring those rights onto the record so the state of Utah can plan accordingly. Federal Reserve rights, kind of an interesting concept. I'll cover it briefly. You could devote a whole day of study to this concept, but long time ago, before the 1800s, around the turn of the century, the Fort Belknap Indian Reservation was trying to appropriate some water in the state of, I want to say, North Dakota. I could be wrong. Could be South Dakota. I believe it's on the Milk River. They went to go appropriate it through the state system, and the state said, hey, tough luck, Chuck. You're out of slits. There's no water to be diverted because all the appropriators around you have already done so. So they sued. They took it to the Supreme Court. The Supreme Court ruled that because Congress had reserved the Fort Belknap Indian Reservation, had taken it out of the public domain, that there was an implied water right associated with that for the purposes of the Indian Reservation, and the priority date of that water right was equal to the reservation date. So subsequent to that Supreme Court decision, that same doctrine has been applied to other federal reservations, such as Forest Service reservations, national parks, national monuments. So all of these, or military reservations even, taken out of the public domain, there's an implied water right associated with them that really we couldn't quantify. The United States would simply say, hey, we got a reserve water right. We're going to use as much water as we want. And states, tough luck, pound sand, we're just going to do what we want type of thing. Well, in the 1950s, there was a senator from Nevada, and he said, well, this isn't fair. The states are trying to appropriate their water rights. They're trying to plan for the future, but they can't do this with this shadow of the federal government behind them, with an unknown quantity of water that they have associated with those reservations. And so we introduced a law, an act that became known as the McCarran Amendment, which in essence waives federal sovereign immunity, because you can't sue the federal government, right? Unless they let you, which is kind of a strange concept, right? Federal government, won't be sued unless they want you to let them sue, right? So, but this waives that immunity, meaning the states can join the federal government, and not only can they do that, they can do it in state district court, and the federal government will be bound by the ruling of the state district court with respect to those water rights. And it forces the federal government to make a claim, quantify those rights, so we know what those are. And so that is one of the things that the general adjudication does. It can only be done under a general adjudication. So it brings that claim and solidifies that. Now, Utah, we've kind of taken a different approach. Rather than simply litigating with the federal government, we've observed other states, and we've noticed how long this litigation goes on and how costly it is. And so really what we do is we still join the federal government, and we say, hey, we got you joined, and if you don't want to play ball, we'll litigate it, because they don't want to litigate it either. What we typically end up doing is negotiating these down from what they want to what they need. And it's been pretty successful in the state of Utah. The state engineer's done a great job of bridging that gap with the Navajos and with the Forest Service. So it's been a pretty successful process thus far. Another reason why we do adjudication is we don't want people going around suing each other over water rights. We don't want a multiplicity of suits, and we just want to get it done, and we want to bring clarity to the water rights picture. Now, you may have, if you watched Gephardt last night, you may have seen me on there, and we talked about use it or lose it, okay? In the western United States, the concept of use it or lose it is pretty common. Because it's such a scarce water resource, because water is such a scarce resource, there's not enough to satisfy every demand. And because of that, that's why the state legislature, as well as other states, have adopted this concept of, if you don't use your water, well, that's water that could be being used somewhere else. And so in Utah, if you don't use your water rights for a period of 7 years or more, it's subject to having the court forfeit those rights. Or even if you don't participate, the court could say, well, you've abandoned them by not participating in this process. And so that's one of the more controversial things, I think, that kind of get people riled up about, the government's coming in and taking our water rights. But if you kind of think about it, the ultimate most fair system in the world would be an unlimited amount of water for an unlimited demand. Well, we face the reality of constraints and resources. We have a finite amount of water with a lot more demand, and so this is how the state of Utah and other states have decided, well, we're going to ensure that people aren't speculating, aren't just getting all this water and forming a monopoly and then holding people subject to their whims. So they said, well, we'll just write it in there. If you don't use it, then the next junior appropriator, he just steps up into line, and that he's able to receive that water, which would have gone to this person who has not used his water right. And so if you think of it, communities, people's lives have developed over this water, which has not been used. And so if you can imagine someone who hasn't used their water for 50 years suddenly go and say, oh, I'm back in, I'm going to turn this water on. And in essence, that causes a shortage down line where people have come to rely on that water for decades. And so is it fair? It's about the fairest I know, but again, the most fair would be an unlimited resource for an unlimited demand. Unfortunately, this is what we have. So we try to make it, the state legislature has tried to make it fair by saying, if you don't use it, then it's going to go to someone who does. And so, again, 7 years or more, and you might be subject to forfeiture. And we'll talk a little bit more about that, and I know there will be plenty of questions about that concept, and I'm happy to answer those. Also, we want to obtain a final comprehensive decree on all the water rights within a respective drainage. In essence, we want these claims to come forward. We want the court to look at them and validate them and and then order a decree on them, making them bona fide and legitimate. So the adjudication process is kind of a three-phased process. The initial phases culminate with tonight's meeting. So if you look at steps 1 through 4 on that little infographic, step number 4 is what we're doing tonight. The petition to do this was started actually by the court back in 1936, but the notice and the summons happened relatively recently. We published notice in the newspaper, and then we send summons out. We also publish that summons. You receive that summons, right? And I understand it's an intimidating thing to get a letter in the mail that says you are hereby ordered to appear before a court to defend your water rights. I get it. I wish there was some other way around that. However, the reality of the situation is it's a court proceeding. We're obligated to send that summons out. Maybe I try to tone it down a little bit with that cover sheet to kind of help explain, maybe talk people off the cliff a little bit. Maybe I need to do a better job at that. But in essence, that's all that is it's joining everyone into this proceeding. The next steps will be kind of the claim filing steps, and we're going to go into steps 5 through 13 in detail here in a second. But this just kind of gives you an overview. So the blue is kind of like where you file claims, we do our evaluation, and we submit that evaluation up to the courts, and then ultimately ending in a final decree on 15. But let's kind of dig into what's going on here. So in maybe a week or two, where's John Azzy? I can't remember the date we're sending the notice out, but in the immediate week or two from this meeting, we will send out a notice. We also publish that notice in the newspaper. So we'll send it out to water right owners of record, but we'll also send it out to property owners. So if you receive the notice telling you to come to this meeting tonight, you'll receive this next notice. And in essence, what it is a notice to file your claims. So if you believe you are a owner of a water right, even if you're unsure, come in and we'll help you. But you'll receive this notice for those who are owners of water rights of record. Now, what I mean by owners of water rights of record there's water rights that have been appropriated that we have a record of on our records. In this area, I think there's somewhere around 130, 160 actual water rights of record. So for those who receive that notice, there will be a water user's claim that's already filled out that reflects the information we have on our database for that water right of record. For the rest of the 11,000 entities, it will be a blank water user's claim with a notice giving them instructions. Now, we don't really expect you to know exactly how to fill that claim. We send it out to kind of let you know that, hey, this is when the 90-day period begins, all right? Now I'm going to get that in a second, but we are here to help you fill that claim out. We'll help you over the phone. We'll even help you if you walk in with it. We will help you determine if you think you have a water right. We'll look and see, well, maybe you have a water right of record, you just don't know about it. We'll look on our database. We have a map system that is very conducive to that. And if you can't find that, then we'll help you file a claim. We'll help you determine whether you really do have a water right or not, or a potential claim. And then you'll be able to file that. So once you've completed that claim, so those are water right owners of record, you can simply sign, mail that back. You can either file it with us or you can file it with the court. Once that notice is mailed out, there's a 90-day window in which you have to file your claim. All right, it's very important. Now you can write to me, write to the state engineer, and request a 30-day extension, but it's got to be within that 90-day window. I'd encourage you just to not wait for that 90 days to expire or even get close to it, and simply just come in and file your claim. Again, we'll help you. We'll walk through the claim process. We know it's not intuitive. We know this is brand new to 99% of the people here, and so we want to make it as we want to be as helpful as we can in this process. If you fail to file your claim within 90 days, you'll be barred from asserting a claim later on in the process, right? So that's why it's important for you to file that claim. Yes, ma'am.
Why is it necessary to do this when we are on file with the water company as an active water user and we pay our dues? Why would it be necessary to go through this process with the state? Can't the water company do that?
So our question is, why is it necessary for me as an active due-paying member of a water company go through this process? Shouldn't the water company be doing this process for us? And the answer is yeah, the water company should. Actually, if you're simply a member of the company or a shareholder in the company, or you have Salt Lake City delivers this water and you pay dues to them, they will be participating in this process for you. So you're right, you don't need to. It's the owner of the water right needs to. If you have a question, whether you fall into that category or not, sounds like from your description that you're paying these fees, these dues to this company, that the company should be the one responsible because they're the owner of the actual water rights. Yes, sir.
So I was going to reiterate that. They're the water right owners. She's a shareholder of that.
Yes, it would appear that way from what she said, that she's a shareholder. So the company owns the water rights. So they're the ones obligated to file a claim. Now, that does, if I were in your boots, I'd make sure that the company's doing that, right? As a shareholder, you have the obligation to ensure the company's following this process. But yeah, they will file it, and there's no fee associated with this or anything. I know it's still a pain because it's time out of your day, right? You got to figure this out. You got to come down. I understand it. We get it. We try to make it as painless as possible, but there's still some time and effort involved. Did I see a hand over here? Yes, sir. So his question is, why did I receive a letter, but the director of the irrigation company did not? The answer is I don't know, but I can theorize why. My suspicion is you are own property within this boundary, and the director of the irrigation company, there's no physical place either that company either falls in the boundary that we get those names and those addresses from the county recorder's office for tax purposes, right? Those are how we get those addresses. What's a little alarming is that if you're saying that your owner, or the director of the company didn't receive it, the president of the company didn't receive it, well, that makes me worried that maybe their address isn't up to date on our database. And so I would just make sure that they are tracking that. They need to ensure that their water right owner of record address is updated with us. But that doesn't prevent them from now. They can still participate regardless of whether they receive notice or not. We just encourage you to make sure they do that. Yes, sir.
We have an association of 8 cabins that have water rights and a users association. Now, can the association, which has a water rights for the city, come and take care of that for all of those, or do they have to do that individually?
So his question is, kind of preface with some explanation, is that he's in there's a association associated with some cabins, some water user association, and his question is, and these cabins, do they have individual wells and water rights associated with them, or? And the water rights owned by the association? Yeah. So if the water rights are owned by the association, then whoever is the president of the association, whoever is the agent for that association, would file the claim on that water right, on those water rights. I presumably if those water rights are all owned by that association. Yes. And you would want to make sure you file them on all 7 rights. Okay. Yes, sir. I'm sorry. I know I'm neglecting. I'll get over here in a second.
When the city claimed water rights for their watershed, that includes where our properties are. And as part of the contract that we negotiated with the city, we ceded all our water rights to the city.
Mm-hmm.
We have to go through this rigmarole.
So his question is, long ago they entered an exchange or a contract with Salt Lake City, who obtained their water rights and deliver water to them based on that exchange agreement. I'm not sure if you're a member of this Parleys Creek Water Users Association or if this is a different association.
This is the Forest Home Company.
Okay. So presumably the Salt Lake City would be interested in filing a claim on that. But I would follow through. What I would do is just come and see us, and we'll look at what you're talking about and see what water rights are associated with that and ensure that they're in the name of Salt Lake City. I can't answer that off the top of my head because I'm not familiar enough with it, though. All right, let's go. I'm going to take like a couple more questions, and we got power through these slides, all right? All right, yes, sir.
Yes, in 1952, the adjudication was there. Who's brought this up? I mean, maybe this is for the Attorney General. Why did you start doing this now?
So his question is, this adjudication's been ongoing. It started back in 1944 and 1936, 1944, depending on which date you want to take. Why are we now just doing this? Well, in truth, we've been doing it, just not in this neck of the woods. We've been doing it in Provo, or Orem. We've been doing it up in Bird's Eye. We've done it on the west side of the Jordan River. So why are we just doing this now? I think it's probably related to the fact that it's time. This is one of the last places in the Utah Lake Jordan River that maybe hasn't had any attention because it's been so complicated. And because it's so complicated, people have just continued to punt it down the road. They just never ever addressed this side of the Salt Lake Valley. So the answer is, it's just there's no ulterior motive. There's no pending water grab or anything along those lines. It's just time. We need to, the legislature is in support of this effort. They've funded the effort, and so it's time to move through the Salt Lake Valley. We've been doing this in Salt Lake Valley for the last 6 years. This just happens, we've just finally gotten around to Parleys Creek. That may not be a satisfactory answer, but that's the answer. What are we planning to do in Parleys Creek? So and I'll explain this a little bit in more in depth. We aren't doing anything in Parleys Creek. If you file a claim, we will come and evaluate that claim. I'm going to get to that here in a little bit. But there's no big project, no pipeline, nothing of that nature that is prompting this action. It just happens to be this time. And just couple of weeks ago, people on Foothill Village asked me the same thing. Why are you doing this to us now? And then a couple of weeks before that, there's the same question from people on City Creek. Why are you doing this to us now? It's just your time.
But you just said, and this will affect Parleys Creek.
It's part of Parleys Creek, the drainage. So I'm speaking in a figurative sense, not in a literal sense that the actual water itself will be affected in any way. Yes, sir.
So if you have a current water share, if you don't go through this process, does that water share become void?
So your question is, if you have a current water share, are you talking about a water share or a water right? You don't know. Okay. So again, so we have the concept of shares and water rights. We are dealing with water rights. So shares are interested in a company, and then the company owns the water right. So I just want to make sure we're clear. And you're probably talking about water rights. And so his question is, if you don't participate and you have this water right, does your water right become void? Does that summarize your question pretty good? The answer is yes. And that's the danger. That's why we send out 11,000 notices. That's why we spend an exorbitant amount of money on getting notice out to people, because we don't want that to happen. We want people to come forward who have claims to bring their claims on the record, because if they don't, what happens, and I'm going to cover this here shortly, is that the court, if they don't file a claim, then they'll be barred from filing a claim in the future, and any claim to water they had before that becomes voided or becomes abandoned. Okay, I'm going to take one more question, and I'm going to drive on, then we'll do another series of questions, all right?
You said you had 140 or so many
Water rights of record.
water rights of record. Some of these companies, there's a lot of us here from White Ditch and Brigham Ditch, all these people here that have shares in those companies. You have a list of which companies actually have these rights, so we know if we've got water rights?
So his question is, you have multiple shareholders from different ditches and different companies. Do we have a list of that? I don't have a list off my top of my head. I don't have one here. I have one on my computer upstairs, and we could look at that. If you came in and schedule an appointment, we could certainly take a look at that. Or if you just called in, we would be able to ferret out what companies, as long as their name is correct on the database. And another thing is that some of these water rights during this exchange with Salt Lake City, in some instances, Salt Lake City is the owner of record for those water rights. So in some instances, it may be a red flag that, hey, do we really own the water rights, or did this exchange transfer ownership to Salt Lake City? And that's really a question between the company and Salt Lake City. But we can certainly look, if you know generally where your water is delivered from, we can figure it out. So I can't do it now, but certainly come in or call up, and we'll walk you through it. All right, I'm going to get through this slide, and then I promise to do another round of questions. Otherwise, we're going to hold up everyone for hours on end. So you have 90 days to file a claim, okay? Once that claim is filed, we will send out a team to go evaluate the claim. It's mapped. If there's irrigation and point of diversion, we'll evaluate it and map it. So there may be some speculators out there who says, oh, I have this water right, I haven't been using it, or I'm going to pretend like I have a water right, but it's buried under concrete or something like that. We're going to come out and actually look at the water right. So please save yourself the time and effort of forging a claim just because you want to maybe profit from it in some way, because we will come out and evaluate. Now, we're gonna give the benefit of the doubt to the water user in every instance, but that doesn't mean we're gonna completely shut our eyes and ignore the facts on the ground. Okay, so you recall how we have these lists of these water rights of record. Well, if there are water rights of record for which there has been no claim filed, meaning there's water right 57-150, if someone fails to file a claim on that, it goes onto this list of unclaimed rights after that 90-day period. And that list of unclaimed rights gets filed with the court, and then notice gets sent out to everyone who received notice of the summons that this has been filed. And in essence, it's just as its name sounds, it's a list of all the unclaimed rights. And there's a 90-day window for people to object to that list. So if you somehow, for some reason, failed to file a claim and it ends up on the list of unclaimed rights, your opportunity to get due process from the court is to file an objection. Now, you have to file that objection with the court. You can't file it with the state engineer at that time. And at the same time, you're obligated to file your claim associated with that objection. And there's a 90-day period. If you file an objection, we have an opportunity to rebut that objection. Usually what happens is if there's a valid reason that they missed their opportunity to file a claim, we don't really fight it much. But if it's kind of a weird thing and it's obvious that someone's just not being responsive or is trying to do something shady, then we probably will litigate it. But for the most part, we want people to file their claims, because what we don't want is what happens at the end of that objection negotiation is the court adjudges those rights on that list as being abandoned, meaning because people failed to participate, that demonstrated their intent that they were no longer interested in the water right, and it was abandoned, okay? And we don't want that to happen. If there's people using their water and people have an intent to keep it, we want them to keep it, all right? That's why we spend a lot of money on notice, because we don't want this to happen. It also, at the time of that decree, it also prohibits anyone from coming forward and bringing an old diligence claim. You remember the 1903 statute and the 1935 statute. If you didn't need a water right before those time periods, well, up until today, you can file a diligence claim and have that recognized. After this decree is issued, that opportunity is foreclosed. No longer allow people to assert those claims. So it's pretty significant, and that's one of the reasons we want to make sure we get the word out. So once the list of unclaimed rights has been published and those block of water rights that aren't filed on expire or become abandoned, the state engineer, after it does his evaluation, our team does its evaluation, will review the claims, we'll make our own determination analysis based on what the basis of the claim is, and we'll file the proposed determination with the court. Now, the proposed determination is, in essence, the state engineer's official recommendation as to how the water rights should look like and how they should be distributed. We file that with the court, and then we send notice out to people who have filed a claim. So it's a little bit different. If you didn't file a claim previously and you're a property owner, you won't receive notice of this. The only people who file a claim or who join as an active party will receive notice of this proposed determination. Other than we'll also print notice in the newspaper, in the Deseret News and Salt Lake Trib. We'll hold a public meeting, answer any questions there might be about it. Again, people have 90 days to object. So in this case, we evaluate a claim, we put in the proposed determination, and it says, Joe, this guy, Joe Jackson, he says he has 50 acres of irrigation. We went out and we evaluated. We only see 20 acres of irrigation, and that's what our recommendation to the court is. Then Joe comes around and says, no, that's a lie. I do have 50 acres of irrigation. I'm going to object. This would be his opportunity to do so. Again, we have to those objections have to be resolved, and they can either be resolved through litigation. We can battle it out with Joe and say, well, show us where your acres of irrigation are, or we can settle through a negotiated settlement. Hopefully, it's the latter. We prefer, if it's just a misunderstanding, then we're going to figure it out. We're not out to rob anyone of their water rights. We want to make sure that the proposed determination is accurate. But once that is finalized, once those objections are resolved, we petition the court to modify or to decree the proposed determination, which is in essence confirms all the rights as they are enumerated in that proposed determination, with the exception of whatever modifications the court decides to make as a result of any objections that were filed. And that's it. End of story. Yes, ma'am. I'm not done yet, but that's the end of the proposed determination process. So her question is, or statement question is, 30 years ago, Salt Lake City, it sounds like you entered into a contract with Salt Lake City, gave up your water rights in order for Salt Lake City to deliver water to you, and now you pay fees, an annual fee or something. Maybe it's just associated with your property. Is this an opportunity then to reclaim those rights? You can claim whatever you want, right? You can file a claim on whatever rights you want, but as they say in the Army, the enemy gets a vote, right? So Salt Lake City, they're going to put a vote down, and they're going to probably fight any type of claim to the water rights which they negotiated through that contract. Again, I'm not familiar with it, but so short answer, no. It's not a window to do that because it probably won't happen. The contract will probably be upheld with court, and it's not an opportunity to renege on that. It's just the Salt Lake City will file on those rights on behalf of their water users that they provide water to. All right. Yes, ma'am. Okay.
I'm not sure what the other subdivision is, but I know the guy's got letters for it. How do I find out that, and do I have to file 2 claims?
So her question is, she's from an irrigation company, and she knows that some of the shareholders have received notices in 2 different subdivisions. Do we need to file 2 claims? The answer is we adjudicate, or we determine whether you need to file a claim in a specific boundary by where the point of diversion is located. All right. So if you have one water right, for the most part, most water rights only have one point of diversion. Some have multiple, but we'll keep it simple here. And so other people may have received notice because they are property owners within a different subdivision, right? But we would adjudicate a water right based on where that point of diversion, so where that stream is being diverted out. If that falls in the area, then that's where that claim would be filed. And once you file a claim on that water right, that's good against whatever subdivisions. I mean, you could file a claim in Provo if you wanted to, and by the time we got there, we'd still honor it and still evaluate it. So file a claim if you have any questions, but you shouldn't have to file more than 1 claim per water right. Just make sure you do it so legally.
We did do an inventory for the DNR of all of our systems, and they wanted to know the cubic foot,
Uh-huh.
and the size of the pipes and all that stuff. And we sent all those maps in this year. Is that part of this?
So it's a great question. So you submitted information. It sounds as part of the canal inventory request, right? Because so it is a separate issue, same division of water rights. We have a person who goes and is trying to get a handle on all the open ditches and all the closed pipe ditches in the state of Utah. And so there's been these requests that have gone out to irrigation companies, public water suppliers, to provide that information so we can have a database of where these things reside, just for first responder and other type of disaster prevention scenarios. Is that part of this process? No, that's different. It's related in that we're interested in where that stuff is, just so we can draw our hydrographic survey maps correct. But no, you'll file a claim, which is different than what you provided for that particular program. Yes, ma'am, in the back. So her question. Oh, you got to be careful with the multi-part questions. I can only remember one at a time. So part 1 of her question is, the fact that everyone received notice here, does that mean that they have a claim? The answer is no. That what you received was a statutory summons, which in essence joined you as a party to this. It does not mean that you have a water right, that you have a claim, but it hopefully brings to people's forefront of their, what they're doing, that if they have a water right, they need to come forward. In a week or 2 from now, we will send out another notice which will have the claim in it that you should file. Now, she asked, do we have a form tonight that we can fill out and file a claim? We don't have any here tonight, but if you come tomorrow upstairs, walk in, we will help you file that claim. So you don't need to wait for that notice to be sent out. We have claim forms available that you can file that claim at any time. I just don't have any tonight. All right, yes, sir. Mm-hmm.
But my nephew owns a lot right below me, and it isn't built on. Do we own connection fees that we don't have to litigate this on? Or what would be the answer there? We have a connection fee with Salt Lake City that was settled through the court.
Sure, I think I understand. So this gentleman lives in Lambs Canyon. During the 80s, there was some litigation that, in essence, from my understanding, I don't know the case, but it sounds like Salt Lake City was forced by court to offer 24 connections, or some number of connections to this subdivision of Lambs Canyon. His question is, does this does he have to litigate this? And he had some question with regard to maybe is your son that had a lot that maybe didn't have a connection on it. I'm just gonna say right now, this is not germane to that. All right, that is a service provided by Salt Lake City. So that's really between you and Salt Lake City. Salt Lake City obviously has water, which they provide that water to you, but it's a separate issue. And they have rights associated with that water, which they will file a claim. But for those connections, it doesn't sound from your description like you need to worry about filing a claim based on those connections, nor is any of that issue pertain to the general adjudication based on your description. If you have more questions about it, certainly come in and we can talk. I always hate to say don't worry about this, because I'm real worried that I don't understand the entire scenario. So my caveat is, if you just have a nagging question, come in and we'll try to sit down and give you some best guidance. But if you really have some technical legal questions, I'd encourage you to seek competent legal counsel with respect to that. I'm going to kind of go over here. Yes, sir. Okay. So his question pertains to use it or lose it. And he said that he has a contract with Salt Lake City for so many acre feet. And what he was curious, what if they only use a fraction of that or a portion of that acre foot? Is that subject to forfeiture? So there's kind of two issues here. First of all, that contract is between you and Salt Lake City. So depending on whatever contract or rules in that contract, or whatever kind of internal rules they have, you're subject to those associated with the contract. So that doesn't mean, so I've seen instances where if you fail to use your water for 2 years in Salt Lake City, they just say no more, you're done. They don't even wait the 7 years. Now, the second part of your question is, does Salt Lake City stand to lose that acre foot amount because of your failure to use it? Well, if you're going to get out your pitchforks, now is the time to do it. Public water suppliers are actually immune from forfeiture. And so they don't, I'm trying to phrase this tactfully here. And this had nothing to do with us. Back in 2008, they passed a law which in essence said that as long as the water is for the reasonable needs of a 40-year plan, that they can, the public water suppliers can't forfeit their water. So to answer your question on that part, no, Salt Lake City doesn't suffer to lose that water. Who passed this law? Well, they live up on a big white Capitol building right up there. You can go talk to them. I'm not sure who the main proponent. That was before my employment at the division. But certainly you can write your legislature if you feel upset about that. Okay, a couple more questions. I'll keep on going. Yes, ma'am. What, will someone help this gentleman find a seat? Are you? Yeah, I can see you. Sorry, you're kind of behind a pole. Yeah. Do you have a question, sir? All right. So your question sounds like, how do you acquire a water right if you want to? Is that? So I just want to make sure we're clear. So when we're talking about, so I'll answer kind of there's kind of two different questions. One is, can I get a new water right if I want to drill a well, or if I want to divert from some creek somewhere and apply it to my yard? And the other question is, can I petition Salt Lake City to deliver water to me to irrigate my yard? I won't answer the question about Salt Lake City because I don't know what their rules are, but you can talk to Salt Lake City about that. But with regard to the water rights, Salt Lake City or the Salt Lake Valley is closed to new appropriations. So what that means is if you want a new water right, or if you want to open a new diversion, you have to acquire a water right from somewhere else, and they do what's called a change application. In essence, move that water to where you want to divert it. And usually that takes the form of moving it from some well over here, buying it from some individual or entity, filing a change, and that change gets published in the newspaper, advertised, And then if it's approved, then you can take that water and drill your well on your property. And so that's really kind of the way you could acquire new rights. Well, that's what I'm talking about, water rights, irrigation water for water. If you wanted a water right for irrigation. I'm not certain about that. You may need to talk to your local municipality. And now you're back behind the pole, so if you raise your hand again, you might need to flag me down. But I'm going to answer a question. All right. Yes, ma'am. No. No, I'm not finished, so you just have to hold on a little bit longer. I can try. I just need to. So, Parleys Creek proposed determination boundary. This is the boundary. You see the same boundary that's on your letter. You see all those pink dots? Those are where we have existing points of diversion located within our subdivision boundary. So there will be maps outside on the table, which will have a little bit better view of this. So if you're interested to see if there's a water right, and they'll have little water right numbers associated with those dots, you can take a look at those later. I've already kind of covered, it looks like we have about 197 water rights of record. I guess it was a little short of that. Here's the issues and anticipated timeline, out-of-date title. So if there's a water right that was appropriated many years ago, and you know, the property has transferred hands a couple times, gone down through the deeds, those records that are on the county recorder's office with respect to that land don't translate to the water right. And so if there's a water right that was under the old ownership information, that's all we have. And so if we send notices out, that's where that notice is going to go for that respective water right. So we encourage people, if they know they have a water right, to update title. There's a process for that here, and we can kind of point you in the right direction. You may need a title professional to help you do that if the title chain does not explicitly list the water right member. Anticipated timelines, notice to file claims will be 1st of November, time-ish, about 2 weeks from now. February is when that 90-day claim filing period will conclude, and then we'll begin investigating claims as soon as we get them. In May 2018, we will publish the list of unclaimed rights. 90 days later, in August, that objection period for the list of unclaimed rights will conclude. And in December, we'll hopefully publish our proposed determination. It depends, because once we get these claims, the complexity of some of these rights may be more so than other areas, so it depends on how fast we can get through that. In March 2019, the 90-day objection period for the proposed determination will end. So that's the timeline. The question is, will I lose my water right? If you have a water right and you're using in the way that is authorized by the records on the state engineer's records, you have nothing to worry about. People who are using water without a water right of record are required to submit a claim. We've talked about this, or risk being barred from doing that in the future. And then again, if water use authorized under the water right has fallen out of a period of use for 7 years or more, or even a portion of it, so if you have 20 acres of irrigation and you're only using 10 acres of that irrigation for a period of 7 years or more, that could be partially subject to forfeiture, meaning you'd only recognize the 10 acres. This concludes my presentation. That's our contact information. That's me up on top. My assistant, Gary Brimley, and then John Bream is the team leader who is going to be responsible for the boots on the ground effort, evaluating your claims, helping you file claims. But, you know, if you come in and he's not available, we'll find someone available to file your claims. Do I have any questions? Sir? Yeah, so once we're kind of done here and once I get some of these questions, I'll navigate to our website and I'll show you where that's going to be located. That's what we're talking about here. So this is our homepage. From here, you can access a lot of different things. If you know your water right number, we can go that. But probably what you're more interested in is looking at aerial imagery or an aerial map and seeing if there are any points of diversion adjacent to your property, or trying to find out what water right numbers those are. So if you look at the home screen here, and we go to data, you see this drop down, it says data. You go down to GIS/maps, okay, and select that link. It'll bring you to this menu. In the upper left-hand corner, there's a water rights map link. And then just select the first link. It says adjudication areas, okay? And that will bring up this interface. And all these purple lines are all the individual subdivisions that we're adjudicating. But we're going to zoom in on Salt Lake City, or Salt Lake Valley rather. And keep on zooming in. Sorry, it's a little cumbersome without a mouse here. All right, so here is, oh, that's not it. That's Big Conwood. There we go, 5714, Parleys Creek drainage, all right? So if we were to zoom in, where should I zoom in? Anyone have any preferences here? Well, Mill Creek's a different area, right? Well, that's this, because that's a different area. So we're gonna stay in Parleys Creek. I'm gonna go down into the, so everything in this purple. So this is the south boundary. This is the north boundary. So everything in here is part of Parleys Creek. Let me zoom out a little bit so you can get a better idea. Just hold on. I will explain it, I promise. Let me get to. Okay, so when I talk about Mill Creek, this is the area I'm talking about, that drainage, okay? See this boundary? That's a different book, okay? We're talking about this boundary right here. Looks like a big elephant, okay? 5714. So this is the adjudication subdivision that we are currently talking about.
Okay, so that purple line with the,
Lots of purple lines.
where it says Milford, where is that line coming down?
What street is that coming down? Let's zoom in and find out. I think that's right. Yeah, it's 33rd, I believe that's right. Yep. So I'm gonna kind of zoom in a little bit here. Otherwise, this thing gets. And I go over to this little. You see over here on this menu, there's something called points of diversion. If I select that little button, all of these little icons pick up. Now there's icons that look like wells and there's icons that look like flowing water. So the red icons with wells on them indicate the location that we know for a water right of record that has a well. The blue ones are for water rights of record that are surface diversions. So out of a creek or a spring or something to that effect. And we can zoom in further. I'm going to go away. I'm going to kind of go over into this neighborhood somewhere. Find one. That is a classic example. See how that well's in the middle of the street? That's not right. That's not true. The location of these points of diversion are based on old measurements overlain with aerial imagery. So you got to take these measurements as reflected in these images with a little grain of salt, all right? So I'm just going to caution you, don't go to the middle of the street looking for a wellhead. But you can select that icon, and it'll bring up some information. So this information is just a summary of some of the components. This is water right 57-7087. That status is something new. It's an underground water claim, meaning that this is a well that was drilled prior to 1935. You can see that by the priority date is 1924. The uses are domestic, irrigation, and stock. That's what that says. But this is the flow rate, 0.056 cubic feet per second. This is the owner we have on the record, Pearl Taft Thurman. This is the location. The location is measured in public land survey units, and I'm not going to get into that, but I can give you a class on that later. But if you select the little water right number, it's a hyperlink that takes us to our database, okay? So we select that, and this gives us more information about that particular water right. So this has a lot of stuff that if you're not familiar with water rights, probably doesn't mean a whole lot to you. But this is where you would come to find out, all right, so this water right, oh, it's kind of shooting off the map a little bit, isn't it? Let's move this. Okay, so the irrigation that it can irrigate 0.5 acres. There are 31 stock units, so imagine 31 heads of cattle or horses. and it satisfied 3 EDUs. EDU is an equivalent domestic unit, or 3 houses. So that's what that means. This was a well that was used for 3 houses, 31 cows, or some assembly of chickens, goats, horses that equals 31 cows equivalently, and a half an acre of irrigation. Okay? And so if you're interested to whether or not you have a water right associated with your house, you can use this interface. And you can actually even go over here. Oh, shoot. This is gonna... Get to the microphone so you can hear me. If you go over to these tabs over here, there's some other tools you can use that might be helpful. For instance, if you want to do a search, if you're not really good at figuring out where your property is on a map, right? You can go over to the search, select this drop down, and go down to address. So someone give me an address they want to look at. Is that like an East Atkin or? You do a search, and it'll drop an X where that address shows up. And you can see from this, there's nothing, no wells showing up in the near vicinity. We can kind of zoom out a little bit and continue to look to see if there's anything close, but you're kind of in a high and dry area. Let's make sure we got the points of diversion. Yeah, you see a couple wells kind of scattered around here, but nothing in the immediate vicinity of your house. Well, this doesn't really map irrigation ditches. It doesn't show anything here. So the point source, if it's an irrigation ditch, would be where the irrigation ditch draws from whatever source. So that's where you'd find that blue icon. Okay? Are there any questions on this interface? Maybe, if that's where it got its water from here. Okay. So, any other questions? I'm happy to answer one-on-one questions if you think you. Yes, sir.